Great. Good morning, everybody. Thanks for taking time to participate in the environmental permit panel petition for permit appeal for the Brown petition this morning. I'm Brad Pagratis from Michigan Department of Environment, Great Lakes and Energy in the Information Management Division today, and I'm just doing a couple quick housekeeping items before we get started. Today is a virtual meeting, so as part of, in accordance with virtual meetings, when you introduce yourself in the coming moments, if you can indicate the county that you're attending from. So myself, I'm attending from Ingham County for the records. Just a little bit of housekeeping on the technology here. If everybody could mute themselves as a starting point, and if as the panel elects a chair and business is conducted, if you can raise your hand, which is done with a little icon at the top of the screen, if you want to participate and make comment, or if called upon, then you can unmute. Cameras will be optional during this meeting, depending on whether you want to have those on or not. And again, the meeting is going to be recorded as we proceed. So with that, I'm going to turn it over to Amy Epke.
Good morning. As Brad mentioned, I'm Amy Epke. I'm a Senior Deputy Director for the Michigan Department of Environment, Great Lakes and Energy, and thanks for joining us today. Just a little bit of background on the Environmental Permit Review Commission/panel. The commission is a 15-member commission that was established a couple years ago in statute. And through that statute, it allows an opportunity for those that have a permit application or those who have a decision after an administrative law judge to go through a process through an environmental permit panel to have the application reviewed. And so that's what we're doing today. Today we do have the Brown petition before the group, and as part of the statute, one of the steps is that the panel is selected by the director. So the director has identified 3 members to serve on this panel, and in just a minute we'll do the roll call and we'll do the introduction of panel members from there. And really our role in the department is to kick off the meeting, and we are separate from the program areas. We also have our Water Resources Division staff on the call as well, who will be going through some of the positions regarding the specific permit. But as far as my role, Brad's and others, we are really separate from that because this is more procedural to make sure that there's an opportunity to hear both sides of the case as well. So with that, I want to go ahead and just do a couple of introductions on those that are helping to serve on the panel. So you heard from Brad Pagratis. He's the Information Management Division Director. We also have Dale Shaw, who will be taking the notes and helping facilitate through this process. And then Bob Reichel as well from our Attorney General's office, who will be serving from the legal perspective today to assist as needed from that standpoint. So with that, I think we can go ahead, and Dale, if you want to go ahead and do the roll call of the panel members at this point. Oh, you're on mute, Dale.
Thank you. Good morning, everyone, and thanks for attending. Per the Open Meetings Act requirements, it's noted this meeting of the Environmental Permit Panel is being held electronically. When I call your name for roll call and you are present, please state the county you are attending from for the meeting, and that will be reflected in the meeting minutes. Tony Anthony?
Here, and I'm I was going to say calling in, but it's I'm from Oakland County.
Oakland, thank you. And Jeff King?
I'm present. I am currently in Otsego County.
Thank you. And Evan Pratt? Oh, you're muted, Mr. Pratt. Just like me.
It looks like you're unmuted, Evan, but we still can't hear you. There's 3 dots on the top of the screen that gives you device settings, and maybe you can find audio there.
Washtenaw County. I do have that. Thank you.
All right, I think I got it now. Is that working?
Yeah, great. All
Thanks,
right.
Brad.
So that is it for the roll call for the panel members. I'd like to now move on to the next step and just go ahead and have the panel members introduce themselves.
Well, as you learned through the roll call, I'm Tony Anthony. At this point, are we supposed to give a bit of a background, our background to help other people within the process?
Yeah,
Oh, go ahead, Amy.
yeah, I'm just going to mention, I think maybe 2 of the 3 members have served on previous panels and maybe 1 has not, but it is helpful if each of you can provide a little bit of background information, because shortly we'll be getting to the point where there will need to be a selection of a panel chair. And at that point, we will be turning over the running of the meeting to that chair. So I think it's helpful to have each member go through a little bit of background and introduction, since many of you may not know each other.
All right, good. I've been working in the industry for over 30 years. Specifically within Michigan itself. I came back to Michigan in 1984. Bachelor's degree is geology. My master's degree is civil engineering, with a specialty of fluid flow through porous media, and also a focus in stream lake estuary systems and modeling those. A little bit over 30 years ago, I started an environmental company, AKT Peerless. We are now in Saginaw, Detroit, Farmington, Lansing, Atlanta, Chicago, Cleveland, and in San Francisco. We've been doing this for quite a bit of time now, working with the regulatory agencies, mostly on the private sector side, and helping clients move through the pathway of environmental regulation.
Great, thank you, Tony.
Yeah.
Jeff, do you want to go next?
After I unmute my mic, sorry. Jeff King. I have been working in this particular field in administration of what is now known as Part 301 of the Environmental Protection Act, Michigan. Since I was employed by the Michigan Department of Natural Resources as an administrator of the program in the field office in 1978. So I worked for the Department of Natural Resources until 1990, and then became a consultant. And after a couple of years, started my own company, which was King and McGregor Environmental. This past fall, after 27 years of being in that company, we merged with Bar Engineering. So now I'm an employee of Bar Engineering. I routinely practice in interaction with the permitting program of the Water Resources Division, particularly as it relates to Parts 301 and Part 303. That's probably 95% of the activities I engage in as a consultant.
Great, thank you. Yeah, hi, I'm Evan Pratt. I'm the Water Resources Commissioner for Washtenaw County. And for the 25 years prior to that, I worked as a municipal engineering consultant. I am a civil engineer by background. Technically, my degree is structural, but I've spent a lot more time in the water area. Like Mr. King, I've had an opportunity to work with the Water Resources Division on 301, 303, 315, and a few other areas that are not so relevant for this particular situation. I was an alternate for a previous panel, and I guess you all gather by the average age of our group here, we've all bumped into each other a couple of times before anyhow. So we will sit here and take the information in and do our best to evaluate how things fit in with the statutes.
Great, thank you, Evan. So next up on the agenda, we have Bob Reichel to talk a little bit about the process overview before we go into the selection of the chair of the panel. Bob?
Good morning, everyone. I'm Bob Reichel. Excuse me, I'm an Assistant Attorney General, and I'm participating from Ingham County. My role in the process is to provide procedural legal advice to the panel as it discharges its responsibility under the statute. As Amy indicated earlier, the statute that governs permitting by Eagle has a provision that created the commission, and the commission acting in panels has two kinds of functions. One of them under section 1315 is such as the situation today where a permit applicant seeks review of the position of the department before the department has actually made a decision on a pending permit application. The other, which of course does not apply today, arises after a permit decision has been made and has been reviewed initially by an administrative law judge. Again, in today's process, we're at the first stage where the role of the commission, the panel, is to consider the positions of the petitioner, in this case the permit applicant, and the department staff in the program with respect to a pending permit application. The statute is not very specific on the role of the panel, but in essence, it says that the panel is to consider the petition itself, any written materials provided by the department staff in response to the petition, as well as the presentations that you'll hear today from both the petitioner and the department staff, laying out their respective positions with regard to the issues raised in the permit. And the responsibility of the panel is to carefully consider that in light of the statute or statutory provisions that are involved in the pending permit application, and ultimately to make a recommendation to the director as to how the dispute should be resolved. And the panel has a wide range of, in terms of what it can recommend. It can recommend essentially upholding the staff position, modifying it, or rejecting it. But again, I want to emphasize that the panel acts in this process in a purely advisory capacity. Its job, again, is to consider the written submissions by the parties, that is the petitioner and the department staff involved in the process, as well as the oral presentations from each that you'll have an opportunity to hear this morning. I'll pause there. If any panel members have questions, either now or during the course of the proceeding, I'd be happy to respond to them. One other point I want to make is that my role is to advise the panel on procedural issues, not to make a substantive recommendation, or to advise you what to recommend to the director on the merits of the dispute or the controversy between the petitioner. It's simply to assist you in a supporting role on the procedural aspects of this process.
Jeff?
Thank you, Mr. Reichel. And a question relative to the written information that is available to the panel. Is it only information that has been submitted to date, or is there some possibility of additional materials being submitted beyond the oral presentations that we will be receiving today?
The statute isn't specific on that point. Certainly, it definitely includes what's been submitted to date. I do believe the panel, if it wishes, would have the opportunity to request additional written information from either the petitioner or the staff. But that's really your call.
Thank you.
John?
Yes, hi, thank you, John Cavito from Bayou Meadows. Just a tangential question to that. Will we be limited to oral presentation, or will I be able to share a screen to help have some talking point charts to help facilitate an oral presentation?
I defer to the department staff on that, but I think that certainly if it would assist anyone participating in this to share their screen, to provide information or points relevant to their presentation, I think that would be perfectly fine.
Yes, I'd agree with that.
I
Thanks,
would.
Bob.
If you need any assistance, just let us know.
Other questions before we go down to the 5th agenda item? All right, so now we are down to the chair designation. And as indicated on the agenda, the role of the chair will be to facilitate the rest of the meeting, recognize speakers, determine if a motion is in order, keep the discussion on track, maintain order, and put motions up for a vote and announce the results. So at this time, we can open it up for discussion among the 3 members, Tony, Jeff, and Evan, to talk about if they have a preference or a motion for a panel chair. And once there's a motion and second and approval at that point, then the meeting will be turned over to whoever the chair is at that point.
Yeah, Jeff and Evan, I've been on planning commissions for 10 years and quarter improvement authorities. I could probably move us through this efficiently and keep us on track.
I'd like to nominate Tony Anthony to be our chair.
I second.
Yeah,
Got it.
all right, good.
Thank you, Tony.
Yeah.
All right, so Dale, do we need to do the vote on that for the motion by Evan to nominate Tony Anthony as chair and the second by Jeff King?
Yes, please. An official vote would be great.
Is it a roll call vote or just all of those in favor?
All in favor?
Okay, all those in favor?
Aye.
All those opposed? All right, with that, Tony, we'll go ahead and turn over the meeting to you. And Dale will continue to be here to support as needed, as well as Bob.
Hey, Amy, can I, just one thing?
Yeah.
Dale has done a tremendous job of letting us know how this process is going to go. And I did not want to forget to say that the information that she provided to us last week and even following along here makes it a very smooth process. And I just want to thank her and give her a debt of gratitude for the work that she's put into this. So thank you, Dale.
Definitely appreciate you hearing or saying that. She definitely is a tremendous asset to the department, and we appreciate having her on the team.
Us too.
Agreed.
Tony, I think you're on mute.
Okay, with that, our first item on our agenda is review and approval of our agenda. Do we have any comments? And if not, do we have a motion to accept the agenda?
I'll move the agenda, Pratt.
And a second?
Seconded.
We have a motion and a second. All those in favor?
Aye.
Aye.
All those opposed? All right, we've adopted the agenda. The next part on our agenda is the presentation from the petitioner. Now, both Jeff and Evan, I'd recommend, simply because of over the years I've seen this be effective, that we allow the petitioner to fully present their case without questions during their presentation, then move on to the state to present their case without question. And then in item 9, it allows us as the panel to ask questions and a discussion, and then we'll go to each one of us. But that not as strictly, it may include some discussion with the panel. Are you guys good with those rules?
As long as I can ask about any words I don't understand while they're talking, Tony, I'm good with that.
Okay, that's good. All right, I don't think that's a voting issue. So to the presenter, we will move on to your presentation. We'll provide you access to the screen to do your presentation. Watch for a hand risen from a panel member for minor questions, but we will try to hold those questions to later on in the presentation. So with that, it's yours.
Hi, Bill, since you're the official petitioner, do you want to kick this off or do you want me to do it, Bill?
Oh, you can go ahead and do it, John. Thank you.
All right. So good morning, panel. Good morning, the department and the Eagle people that are on with us this morning. My name is John Cavito. As a very brief background about myself, I didn't know anything about Eagle until about 3 months ago. I'd never heard of Eagle. I'm new to Michigan. I'm new to this side of the state. I've been in this community for about a little over 3 years, and I was co-opted, arm twisted, and browbeat to become president of our condo association about 6 months ago. So unlike the other 3 distinguished panel members there, they're going to be hearing the case. I know nothing about fluid dynamics. I know nothing about the waterways. I know nothing about 301 other than the crash course that I had from Bill over the last 3 months. So I'm coming at this as purely a recreational, as a homeowner and a slip owner and a recreational boater. But a little bit about my background, just so you'll have some context. I'm a retired Army officer, retired as a colonel after 32 years. I now am the president of a couple manufacturing companies here in Walker, Michigan, and I'm in Ottawa County. As I said, I've retired from the military 3 years ago, and I've got a defense company that's underneath me and a commercial automotive doing primarily tier 1, tier 2 work for GM, Ford, et cetera, and then all the defense big contractors. So that's my background, and I'm the president of our condo association. Our condo, and there'll be a slide here in a minute. And Bill, maybe you want to introduce yourself real quick before I hit the slides?
Sure, John. My name is Bill Brown, and I've lived here in the HOA for about 17 years now. I originated out of the Cleveland, Ohio area. I'm a federal law enforcement officer, have been for 21 years. Worked in Cleveland for 6 years, came back here for 16, and right now I work in Cleveland probably for the last 5 years of my career, but I still live here in Bayou Meadows Association in Ottawa County. So I appreciate everybody's time, especially since we pulled so many people together to take a look at this. So thank you very much, everyone.
And so, thanks, Bill. And so with that, gentlemen, ladies, I'll go on to what our agenda is. And the things that I'd like to talk about, if it's okay, is the purpose and what I think is our key takeaways, a little bit about who Bayou Meadows is, some context to help frame the discussion. To go back in time almost 20 years, the Bayou Meadows original approved Marina plan, the discussion about our current application, and then a summary. So with that, because of my military background, we always try to talk what we call about the bluff, the bottom line up front. So I'm going to go into our purpose and what I think is a bottom line of how we see the world, and then go into the background and context to at least give you the bottom line up front. And the first is that through a series of discussions, we've had what seems to be a compromise from Eagle at a 4-foot wide finger pier to our request of a 5-foot wide. And when you look at that in the context of the surface area of Petty's Bayou, not even all of Spring Lake, but just our small bayou, that difference constitutes a 1/1000% difference to the surface area of Bayou Meadows of where we are and the compromise that Eagle has offered us. The difference between our original finger pier and the requested finger pier is about 2/1000% to the surface area. So from the 1999-2000 approved width of a finger pier to what we're asking for today is a 2/1000% change to the surface area. Our total impact of our marina that we have today, even if you were to recommend and the director were to approve or Eagle were to approve our 5-foot wide finger pier, would still be 32% smaller than what was originally approved by DEQ in 2001. So our total footprint is still going to be substantially less than what was originally approved, which originally was 26 finger piers and a couple thousand feet of head pier. Our request will have an infinitesimal impact to the environment and the public trust, especially relative to what was previously there, the size of the body of water, and other recently approved projects. And then so to go along with that, the key takeaways as we see, I know that and I was unaware of this, I did not know that we were legally defined as a marina. but I think Marina, I've got in quotation marks because we are a private, non-commercial, recreational marina in that the incorporation of Bayou Meadows 2 Condo Association Incorporation is a nonprofit corporation that owns community property. Part of the community property is a head pier with finger piers. And then we'll talk about that in a couple more charts. And then I'm not trying to tell you something you don't know. I'm sure you're more aware of this than we are by 1,000-fold. But when we looked at Part 301, we looked at the three things that the department shall, give a permit in 301. If the marina with these three check marks or these three areas that, at least from our non-legal perspective, and by the way, we have no legal counsel helping us with this, and perhaps we should have hired a consultant firm and spent several $1,000s on a consultancy or lawyers to help us, but it's Bill and I, two volunteers in the association. And that right now that our marina extends from the riparian rights of the applicant, and our marina is actually is circled by 80% of our property. We go around the entire marina on both the west side, the north side, and the east side. And the only thing that's not surrounded by our property is the south side. We do not believe that what we have done will unreasonably interfere with navigation. And the marina is located and designed to be operated consistently with the other correlative rights of other riparians. And I think that you'll see by some of the presentation that we believe all that to be fact. A little bit about who Bayou Meadows Condominium Association is. Under the Public Acts of 78, we are considered a condominium. However, there are no what I would have traditionally thought as a condo here. These are all individual houses sitting on individual lots. But apparently in Michigan, if you have communal property like our entrance or our walking path, then the entire thing becomes a condominium. My house is on about 0.6 acres. Bill's probably got half an acre. And so Bill and I represent 2/3 of our board of directors. I'm the president, Bill's the treasurer, and we have one other member director. We're all volunteered, non-paid. And we're trying to manage, administer, and maintain the affairs of Bayou Meadow 2 condominium project. The project includes 23 individual home sites. This marina, again, in quotation marks, because we don't feel it's not a traditional marina. There's no gas dock. There's no restaurant. All the slips are privately owned. Although the slips, it's a very interesting thing, and maybe people who buy in here, including myself, should have read the fine print and the HOA documentation. That although the marina is owned by the condominium association, we are all responsible for the maintenance, repair, and replacement of the marina as owners of the slip. So we have a deeded slip piece in the middle, but we don't own the finger pier as individuals, and we don't own the main head pier. So a little bit about context, and just so you'll know, we fully understand that every single permit is viewed in isolation or as an individual standalone, but we still think it's important to understand some context of how at least we see the world, so you'll see how we're coming at things. So the first is just to give some context of some very recent applications, and again, understanding that everything is individualized and every site is site specific, but I think it's important for context. This is coming from north to south into Grand Haven, and it's called Four Winds Marina. And this was a year ago satellite picture. This is Four Winds Marina today with 12 finger piers, six floating hinge piers from the dock, a 6-foot wide floating head pier with 12 5-foot wide or 4-foot wide floating finger piers. Again, something that has just recently been introduced that somebody thought that this was reasonable and that this did not interfere with the public trust and was reasonable for navigation. So all that surrounds this headland right here. One of the next ones is the Spring Lake Yacht Club. This is Spring Lake Yacht Club before, and now this is Spring Lake Yacht Club after. So again, this was viewed at the time, this was done over the last 5 or 6 years, that this massive addition was reasonable, that it did not interfere with the public trust enough to be denied, and it did not interfere with navigation enough to be denied. The next one is Barrett's Marina. I don't have a before and after, but the red boxes show everything that was done after. Outside of the red boxes was the original And out in the red boxes was something, again, that was deemed to be reasonable and not interfering with public trust, nor navigation or the environmental impacts. And then Grand Haven East Point RV Park. This is a before picture, and then the after picture that goes all along. And you can imagine there that, you know, they don't own the riparian rights across from them, so they have lots of riparian rights in addition to navigation and environmental impacts. For complete transparency, the upper right picture that says after, where the red box is, that is a Photoshop. I've added those extra dock spaces because I don't have an aerial view, but you can see from the bottom pictures that I took from my boat what's actually been put in place, and it goes completely up the shoreline. Now, I just wanted to have complete transparency that the red box, it was just taking the bottom right-hand section of what was originally there and then pasting it in 2 times above it. But you can see from the physical pictures that I copied and pasted in the bottom. So that's sort of the context. Again, understanding that every one of these permits is done specifically, site specific, and it's not supposed to bleed over, but at least from people without a lot of experience in that, that's what we see when we're driving around as a resident of Michigan, as a taxpayer here in Ottawa County, and boating on Spring Lake and the Grand River. You know, it's what we see. And then the next point is, you know, now for the Bayou 2 Condo Association Marina. The originally approved plan for the marina was 13,000 square feet, 8,480 feet of shorehead, square feet of shorehead pier, 1,400 square feet of perpendicular pier, and 3,120 square feet of finger piers. And this was the original permit there. You can see the in December 31st, July 3rd, 2001. And you can see originally this marina was scheduled for 26 3-foot wide by 40-foot long finger piers. And the next chart will show you a schematic of what that looked like. So this is what it was going to look like here in Bayou Meadows. It was going to go north to south, Maidenhead Pier about 560 feet with 14 finger piers. Then around the east or the west-east running another over 1,000 or 600 foot head pier with another set of 10 finger piers, and then a perpendicular pier that went behind lots number 12 and 13 for lots 12 and 13, and an easement for the people out on this road to get to that. So that was the original plan. 13,000 square feet of a marina was originally approved to go here. Bayou Meadows, until the summer of 2019, all that was ever put in here. So over those 20 years, all that was put in here was the 560 square feet of main pier, and I'll show you a picture here in a moment, and 14 finger piers measuring 3 feet by 40 feet out of the 26 that were originally approved by the developer of the association that were put in here. So that's all that was ever put in. You can see the picture that was what was established. The other 12 finger piers were not put in, the other head pier was not put in, and the other perpendicular pier was not put in. So we were the developer put in less than 50% than what was planned for this area. Bayou Meadows today, you'll notice something oddly missing from that photo. Our finger piers were awash for almost 24 months with the high water because they were fixed finger piers put in with no steel reinforcement. It was a 100% wooden finger pier that was put in, wood frame. They were put on steel posts, but the frame was wood, the fascia was wood, the decking was wood, and it was fixed. Unfortunately, it was fixed about 18 inches below the 100-year floodplain. The water came up so high it got to within about 6 inches of our main head pier that you see there. But that head pier was put about 8 inches above the 100-year floodplain. So we were able to salvage the head pier, but those finger piers all had to be ripped out at our expense. We did get a permit. We were permitted for, and we ripped out at our expense all of those finger piers. So that's what it looks like today and what it has looked like now, Bill, for what, about almost 10 months now ago. We had the finger piers ripped out last fall. They were finally able to get a barge in here with the high water, and we were finally able to get the finger piers all ripped out. So as you can imagine, that was not a trivial expense for us. This is Petty's Bayou. So this is where we're located. You can see my cursor. If you can see my cursor, that's Petty's Bayou. This is Fruitport Road, and then Spring Lake is down here to the southwest. So Petty's Bayou is here, and where my cursor is, you can see, if I were to zoom in there, you could see that blue, very faint blue line that represents our finger pier and our main head pier. The original plan went all the way around where my cursor is going right now, from the southwest to the northeast here was where the other portion of the finger or the dock was supposed to go. So Bayou Meadows 2 Marina, total approved back in 2001, as I said, was 13,000 square feet. And that 13,000 square feet would have represented 2/100ths of the surface area, 2/100% of the surface area of all the 5,300,000 square feet of Petty's Bayou. What was actually approved, what was actually done was 6,160 square feet. You can see there that what was actually done between the shorehead pier and the finger piers. The previous finger pier footprint of a 30-foot by 40-foot by 14 constituted 3/1,000ths of a percent of the surface area. The Eagle compromise, at where Eagle is recommending that we go to a 4-foot by 40-foot, would represent, again, 4/1,000ths of a percent. So we're where we are and where Eagle is 1/1,000th of a percent difference to the surface area of Petty's Bayou. Not even all of Spring Lake, just our small little bayou here that we live. You can see where we live, where my cursor is. That's our community, and then there's a walking path from our community that gets us down to our dock. So again, it's called a marina, but it wouldn't look like a marina from in many other people's context of what a marina is. It's also constrained by this bridge. This is the Fruitport Bridge, and this bridge gives you about 8 foot of clearance. So you can get, if you don't have any kind of fly bridge, you can get a 30, 35-foot boat back here if the water's down. For 24 months, you weren't getting even a 25-foot center console. You couldn't get underneath that bridge. Now that the water's down, some of the other folks that have a 25-foot center console and 30-foot boats can get back to their slips. But for 24 months, many of us were forced to keep our boats in and out storages and other places. And then the current requested footprint, again, like I mentioned, our original footprint would have been 3/1,000ths, Eagle compromise 4/1,000ths, and what we're asking for represents a 5/1,000ths of an impact, a 5-foot wide by 40-foot. So to the public trust, where we sort of view the public trust, our riparian, this is to the east here is all Bayou Meadows 2 Condo Association property. And this finger that you can see here, when it's above water or below water, this is also our condominium property that comes all the way out here. So we have riparian rights, like I mentioned earlier, that are 75–80% surrounding our marina, our slips. And because our request does not extend the length of the finger pier, the length remains 40 feet. We aren't going further out into any kind of navigable water, because I fish right here, Bill does, and other fishermen come in here all the time. But because we're not going further out into the water, much like Spring Lake Yacht Club did or some of the other place, we feel that the encroachment and to the public trust is really pretty minimal, because we're only making our finger piers wider. And the wider finger piers are encroaching with an easement onto our individually owned slips. It's not going further out into the public trust, although, as we've been informed, the public has the right to fish wherever the water grows. So if you're making your finger pier wider, yes, you are taking up more lake or surface area, but like I mentioned before, it's really an infinitesimal, not, in our opinion, not an unreasonable addition. And like I mentioned, as I just said, the space in between the finger piers is privately owned. You can see that's my deed with Ottawa County there in Spring Lake, the township here. I'm in slip number 26, unit number 24. So there, in between each finger pier are 2 individually deeded properties. So that's that's my property where the red box is. And so any encroachment becomes since we're asking for our finger piers to be 2 feet wider, going from a 3 foot wide finger pier to a 5 foot wide finger pier. 1 foot's going to be on my property. 1 foot's going to be on Bill's property on the other side of the finger pier. So this is what you're looking at there. My orange boxes around the finger piers, the original finger piers. That's what is the approximate size of our requested addition. If we were to put in exactly what was there before, then there wouldn't be an orange box. It would just be the gray finger pier sticking out. 2 feet wider than the 1999 requested permit. I guess it took almost 2 years to get the permit approved for the 30 foot by 40 foot wide, 3 foot wide by 40 foot long finger pier. 1 foot wider than the Eagle compromise through our informal discussions where Eagle was suggesting that we go to a 4 foot wide finger pier versus a 5 foot wide finger pier. Our main pier, for context, is not floating. Why is that important? It's important because in order to go to a floating finger pier, because we're trying to be prudent and deal with the really substantially fluctuating water levels, you have to have a hinge transition piece to go from a fixed main dock to a floating dock. Without a hinge transition piece, because the water's up almost 2 feet where it was a year ago, and I don't know what we'll do between here and the fall. I don't know how much this is going to continue to go. So we thought it was prudent to have a floating, if we're going to put new docks in, to put a floating dock in, and therefore you have to have a hinge transition piece. The orange box again around it represents what is the increase in size from the originally approved 2001 permit. Again, keeping it at 40 feet long, but requesting to go from 3 feet wide to 5 feet wide. And you can see now what the footprint would look like. Narrower options were available. But after talking with the guys that are doing these floating finger piers, and these are not industrial finger piers, these are these commercial off the shelf, whether it's can dock or it's wave armor. And because we have almost a half-mile fetch from west to east, we get really, the prevailing winds are substantial from west to east, and we can get, as you know, here in Michigan, coming off Lake Michigan, it's not uncommon to get 15, 20, 25 knot winds to come through there. And the representative said, and we looked at a number of different companies, and yes, there are 4 foot wide floating docks, but we thought that it was prudent for us and our community because we're Bill's one of the younger guys in the community, one of the younger residents at 43. I'm 53. I would say that I'm in about the medium range of the homeowners that are here, and then it goes up from there. And as you can probably know, a 3 foot wide floating pier, you're not walking 2 by 2 on a floating finger pier, and it becomes, the wider you get, the more stable that floating finger pier is. So we thought for safety and prudency, and because we didn't feel that it would interfere with navigation of any of the waterway that was out there, or that it would not be an unreasonable infringement to the public trust, we thought that a 5 foot wide floating finger pier would be perfectly acceptable inside the bayou that we live on. So there you can see the original 3 foot by 40 foot finger pier. I couldn't get the numbers as I was trying to draw this box. This is off of Google Earth. So Google Earth did the calculations here for me, was about 120 square feet. The Eagle Compromise was suggesting a 4 foot by 40 foot finger pier, which would have constituted 160 square feet. And our request was for a 5 foot by 40 foot, which was a 200 square foot floating finger pier. Again, the encroachment was a 1 foot encroachment easement onto my private property and Bill's private property. But again, as the Eagle people told us, that our property isn't really the surface of the water. Our property is the land beneath the water, and everything above is public trust. So I guess we have to acknowledge that if that's the law and that's the fact, right? So yes, but we think that that's is minimally intrusive to any kind of rights that the public has to fish there. Like I mentioned, a 1/1000th of 1% difference between the compromise and what we have. So this is what we had. can see there the main dock and the 14 3-foot by 40-foot finger piers. And this is what we're requesting. When we think about the totality of Spring Lake, Bayou Meadows, not being more than the 40 feet it originally was, we think that this sort of meets those definitions of that it extends from our riparian rights. It's not an unreasonable encroachment to anybody else's navigation or anybody else's public trust fish, or being able to fish. And when we did the public notification for how it affects other people's riparian rights, there were no responses to any of the public notices that went out, whether it was Corps of Engineers or whether it was Eagle public notification. There were no negative. Actually, I don't think there were any responses. I know there were no negative responses. So in summary, and this wraps up our presentation, Bill, and please, when I'm finished with the summary, if I've missed something, we're a volunteer group of homeowners trying to manage the association. The 2 years of high water destroyed our finger piers. They're requesting the 2 foot wider, but the same length of the original finger pier. I won't go over those numbers again. Originally 13,000 square foot marina approved, 6,100 was constructed, and we're only looking at, even if this is approved, if we go to a 5 foot wide finger pier, we'll still be substantially less than what was originally approved from this neighborhood. No public notice negative. The public trust we think is an infinitesimal impact, and that was from what was originally put down, the 3 foot wide to 40 foot long. The environmental impact is negligible. It's hard for, we are unable, we're not scientists, we're not biologists, we're not environmentalists, but on such a small footprint increase, we don't understand how it could be denied or what the negative impact could possibly be when other things are continuing to be approved on the lake. We do acknowledge there are other options. There are other options. We could go with the 4 foot wide. We could cancel everything we have right now that's already been booked, but with the shortage of raw materials and how backlogged everybody is from repairing all their damaged property for the last 2 years of high water, it would be another year before we have finger piers in the water. But we were trying to balance the public trust, safety, cost, and what we think is a total impact. And then we acknowledge that we could have a smaller impact. We could make it smaller. We could go to 4 feet. We could go to 3 feet. We could do nothing. But so could Barrett's. So could Spring Lake. So could East Point. So could Four Winds. Everybody could have gone a foot smaller. But when we look at what is reasonable and prudent and feasible, we think that we fall into that category of what we have is prudent and it's not unreasonable. If the burden is that it not be unreasonable, we think our request is reasonable. And gentlemen, that's it. That's our presentation. And I'll pause there, Bill, for anything that I may have missed that we talked about.
John, I just wanted to say one thing and just bring this to light. And I talked to Bonnie about this and some of the other reps when we had our conversation. One of the things that we did consider, and I just wanted to make sure that the panel knew this, is that if an alternate solution, which in this case, if we ripped that main shoreline pier down, which we wouldn't do, it didn't suffer all the damage like it did from the finger piers, and we just put $2,000 in plumbing into it. We put about another $2,000 in replacing a lot of the boards on that pier. Just this season alone, even though we don't have finger piers out there, we're investing money into that main shoreline pier. And if it wasn't for the fact of going from the main shoreline pier and using those transition ramps to the floating finger piers, I think we could have had an alternate solution where we replace the whole entire thing. But I know that if we had to rip down that main shoreline pier, which wouldn't make a lot of sense because it's still usable and we feel like we can get another 15, 20 years out of it. But if we did that, as the treasurer for the homeowners association, we did go down that road and we found out that is it feasible for us to rip that thing out? Yeah, we could do that, but it would cost us $270,000 just to rip that main shoreline pier out to put a floating pier in there. And if we did that, we would not have that transition piece, and we probably could go to a 4-foot wide finger pier. But because we're trying to keep that main shoreline pier out there, it wouldn't be fair, or it wouldn't be feasible if we had to incur that higher cost. Our project right now is $156,000, and that includes the finger piers, and approximately $28,000 of that is the demolition, which we've already paid. So I just don't think it would be feasible for us to put the 4-foot wide finger pier out there and incur another $270,000 for all of the private non-commercial residents in this neighborhood. Because again, and John brought this up a few times, and I know when I first started talking to Bonnie on this permit application, I was surprised that we were listed as a marina, because if you came into this neighborhood, you wouldn't look at that and think that that was a marina out there. You would think that that is just a handful of docks that the residents in this neighborhood have. So I just at least wanted to put it on the record that that we would incur a higher cost if we had to transition to that 4-foot floating finger pier, because it would force us to replace that main shoreline pier at the cost of $270,000 extra on top of the $156,000 that we've already paid. So I appreciate your time. Thank you for listening, and thank you, John, for your presentation.
All right, thank you. Jeff or Evan, do you have any urgent or immediate questions for these guys that we can't pick up after the final presentation?
I'm good with continuing. Jeff is.
I'm fine with continuing to, as relative to that presentation, it would be good for us to be able to get a copy of it at some point in time.
Good. All right, Jeff and Bill, thank you for your presentation. And at this point in the agenda, we'll move on to Eagle's presentation on their view of the permit application.
Good morning. My name is Bonnie Broadwater. I am a senior environmental quality analyst with the Michigan Department of Environment, Great Lakes and Energy, and the staff person who is reviewing the application. I've worked with the department for 4 years, and in that time, I've reviewed over 500 permit applications. I have a bachelor's degree in biology from the University of Michigan and a master's degree in environmental science from Indiana University with a focus in aquatic ecology. This is a Part 301 Inland Lakes and Streams application for widening of finger piers within an existing marina. Although the department has not officially made a determination on the permit at this point in time, the application does not adequately identify available alternatives. Additionally, based on what has been proposed, the adverse impacts to the public trust in the environment are more than minimal from the proposed project, and feasible and prudent alternatives are available. This project is regulated under Part 301 as a marina. A marina is defined by Section 30101 of Part 301 as a facility that is owned or operated by a person, extends into or over an inland lake or stream, and offers service to the public or members of the marina for docking, loading, or other servicing of recreational watercraft. Section 30102 of Part 301 identifies that a permit is required to construct, reconfigure, or expand a marina. And Section 30106 of Part 301 states that the department shall consider the possible effects of the proposed action upon the inland lake or stream and upon the waters from which or into which the waters flow, and the uses of all such waters, including uses for recreation, fish and wildlife, aesthetics, local government, agriculture, commerce, and industry. The department shall not grant a permit if the proposed project or structure will unlawfully impair or destroy any of the waters or other natural resources of the state. And this part does not modify the rights and responsibilities of any riparian owner to the use of his or her riparian water. A permit shall specify that a project completed in accordance with this part shall not cause unlawful pollution as defined by Part 31. Additionally, Administrative Rule 4 states that in each application for a permit, all existing and potential adverse environmental effects shall be determined, and the department shall not issue a permit unless the department determines both of the following: that the adverse environmental impacts to the public trust, riparian rights will be minimal, and that a feasible and prudent alternative is not available. Links for Part 301 and the administrative rules were provided to you with your copy of this narrative. To provide some history for the site, a permit was issued in 2001 under Part 301 to construct a new marina, including a fixed head pier and fixed 40-foot long, 3-foot wide finger piers extending from that head pier. A portion of the permitted structures were subsequently constructed with the finger piers installed at a width of 3.5 feet. These structures were not in compliance with the issued permit, which was expired on December 31st of 2005. On August 24th of 2020, Bayou Meadows applied for a general permit to remove the existing 14 3.5-foot wide finger piers, which had become damaged because of elevated water levels and ice. At the time of the application, Eagle staff discussed the need to review the entire project, including any proposed replacement finger piers in its entirety with the applicant. Citing concerns related to human health and safety and impacts to navigation, the applicant declined to apply for new finger piers at the same time and requested that Eagle move forward with authorization to remove the existing structures only. A permit was issued in November of 2020 and the non-compliant finger piers were removed. Then on December 17th of 2020, Bayou Meadows applied for the replacement of the 14 finger piers with a new proposed width of 5 feet. This expanded configuration constitutes a total increase of 1,120 square feet over the finger piers that were originally authorized at this location. And the new piers are proposed as permanent floating structures, while the previously permitted structures were proposed as open pile. The applicant informed Eagle that they had already purchased the docks and their original application materials. During subsequent communications with the applicant through the review process on February 18th, May 5th, and May 14th, Eagle repeatedly asked for additional feasible and prudent alternatives analysis, which addressed the proposed width expansion of the finger piers from 3 feet to 5 feet. Alternatives identified by Eagle for consideration included alternative designs such as narrower floating piers, open pile structures instead of floating, alternative vendors that may offer narrower configurations, and/or alternative vendors that offer the necessary hardware to affix available narrow floating piers to the existing fixed head pier. On May 5th, during a phone call, Eagle discussed the acceptability of a 4-foot wide finger pier with the applicant as a less impactful alternative than the proposed 5-foot wide design. This offered reduction would minimize impacts to the lake while still accomplishing the stated project purpose of replacing the docks. The applicant then inquired about the procedure for adding boat hoists to the existing slips and the procedure for filing a contested case if a denial was issued by Eagle for the application. This information was subsequently provided via email. And on May 26th, approximately 2 weeks before the processing deadline for the file, the applicant filed a petition for application review with the Environmental Permit Review Commission. With this petition, the applicant provided a vendor narrative and specification related to their selected design. This information was not previously provided to Eagle in any communication with the applicant or in the contents of their original application. During 2 subsequent meetings with the applicant, Eagle discussed alternative configurations and project specifics at length. And at Eagle's request, the applicant provided a spreadsheet of other configurations they considered and rejected, as well as specifications from the other vendors that had provided them with quotes. During these meetings, the applicant also identified that they had already placed a deposit on their selected configuration and that a change to the design would significantly extend their material delivery timeline and/or result in the loss of their deposit. During these meetings, the applicant also identified several area marinas, including Spring Lake Yacht Club, Barrett's Marina, and Hall's Sports Center, also referred to as Four Winds, and East Point RV, all of which are in the Spring Lake and Grand Haven metro area. While several of these commercial marinas offer more and or longer slip configurations, a review of the permits issued in My Waters confirms that all authorized finger piers for these marinas were 4 feet wide or less, which is consistent with what Eagle offered to this applicant. During informal negotiations, after discussing an additional alternative configurations, including a shorter dock at the applicant's desired 5-foot width, so that the net impact to bottomland would not be increased, the applicant then asserted that the hinged gangplank, currently proposed at 10 feet long, does not constitute an impact over bottomland and should not be counted toward their permit length. This assertion is not supported by Part 301, as the gangplank is a regulated structure over bottomland which requires a permit. On June 17, 2021, Eagle received a legislative inquiry regarding this file from Senator Victory's office. The unresolved issues identified by the department are as follows. The proposed dock width expansion does not constitute a minimal impact to the environment. The 14 previously permitted finger piers, each measuring 40 feet long by 3 feet wide, were authorized for a total of 1,680 square feet of impact. This proposed configuration of 14 docks measuring 40 feet long by 5 feet wide is a 2,800 square foot impact. This is a 40% increase in impact area overall. The proposed dock width expansion will result in adverse environmental impacts. This area borders emergent marsh and is proposed over bottomlands which provide aquatic habitat, spawning areas for fisheries, substrate for macroinvertebrates, and aquatic plants which support the food chain and provide dissolved oxygen. Shading over bottomland from proposed structure expansion will further degrade the ecological functions and values of these areas. Please see the attached narrative regarding expected negative impacts to the aquatic environment and associated references regarding these structures. Feasible and prudent alternatives to the application are available to the applicant, including the installation of narrower floating structures, which the applicant has identified as commercially available. Alternative hinge configurations to allow the attachment of narrower structures to the existing fixed head pier, and alternative finger pier designs such as open pile docks that would address the stability issues identified by the applicant with narrower floating structures. All of these alternatives are consistent with designs authorized in other areas on permitted marina projects. The applicant's additional information provided after filing of the petition for the permit application review appears to support why the chosen alternative is desirable from a cost standpoint, but it does not appear to explain why the other alternatives are not feasible and prudent to minimize impacts. The applicant's assertion regarding forfeiture of their deposit to the vendor and or their acceptance of delivery of docks ordered from their vendor during the ongoing negotiations with Eagle are not relevant to the review under Part 301. And that's it. I'm all set.
Had to find the mute button. All right, good. So Bonnie, that's it on your presentation. And with that, we're able to now move on to the panel questions. Jeff, do you want to start us off with questions?
Sure. If you could just give me 1 minute to go back over some of my notes on, is it Cavedo? Is that how you pronounce?
Yes, good morning. It's John Cavedo.
Cavedo, okay. Mr. Cavedo, thank you. Most of the questions that I was writing down, you answered as you moved through your presentation. It was very thorough, so thank you for that. The only question that I have goes more to Mr. Brown's comment at the end when he was talking about the cost of removing the main pier and the significance of that cost relative to the overall project cost. Could you just describe again why you were considering removing the main shore pier? Was it to reduce the area of impact, this area in dispute of however many square feet that it happens to be? Was that part of the consideration as to why you would think about removing it, or was it more a function of the practicality of the overall structure?
I brought that up because I know one of the things that Eagle looks at is an alternative that entails a higher cost, and that Eagle would determine that that's not feasible and prudent if those higher costs are unreasonable. And if our main shoreline pier, and John, you can explain this maybe better than I can, the main shoreline pier is fixed, and we're trying to put floating finger piers out there and attach them to the fixed main shoreline pier, which is made out of wood. If we took the whole project down, if I would have gone to Bonnie last year and said, hey, this whole thing is a mess, we got to take the whole thing down, we would have had proposed a floating main shoreline pier, that big giant 500 and plus foot, main pier that would have been floating. And if we were to do the alternative, or the proposed alternative from Eagle of 4 foot wide, connecting those 40-foot, 4-foot wide piers to the floating main shoreline pier would have been doable for us. But because we still have that fixed 550-foot long wooden shoreline pier, which we plan on keeping for another 15-20 years, we're stuck with trying to attach a floating pier to the mainline pier. And I just brought that up because if we had no alternative, we can't put something out there that's safe. And I think safety is our biggest issue with the 5-foot wide floating piers. I wasn't on the committee that presented all the alternatives or did all the work, and I know that we had that guy on one of the calls with Bonnie where he explained how we contacted 3 different contractors. I believe we looked at 4 different products. Even before this panel, we were looking at some other alternatives that we didn't present today, but we tried to go through all of our alternatives for making a 4-foot wide, 40-foot pier work, and then we just can't get anybody to come out there and assure us that it's going to be safe. We feel like we're going to have a safety issue out there, and with us being a non-commercial private neighborhood here, we're taking into consideration the fact that most people are in their mid to late 50s. We have a 70-some-year-old lady that has a finger pier out there that she uses her boat on, and we're looking at, why that works for us because we're connecting to that main pier. But if we had to replace it, if Eagle tied our hands and said, hey, you guys have to do a 4-foot wide, 40-foot, then we may have to consider ripping that main shoreline pier down. And we got an estimate for that, and that was $270,000 to rip that out and replace it with floating main shoreline pier at the length of 560 feet. So where we had a project that cost this neighborhood $156,000, and that's money that we divide by 28 people because we're just homeowners here. We don't have any commercial aspect of that project down there. And I know it's called the Marina, and we talked about that, but right now we've funded $156,000 for the current project. And if we had to rip the shoreline pier down, that would cost us an additional $270,000 that we would have to invoice. And I just don't even think that we can do that. I think to go back to the neighborhood or 28 individuals and ask them for another $10,000 to $12,000 to try to make a 4-foot wide, 40-foot finger pier work, I think we would have I think we wouldn't be able to do it. And I don't think it would be reasonable. Did I answer that question?
Yes, I just have one.
Maybe I can help. If I might be able to just expand a little bit more. When we're going from the fixed finger pier to a floating finger pier, you have to have the transition. The transition now takes up part of the 40-foot length. That transition is not dockable. right? It's an aluminum hinged ramp that go, and it's not dockable. And now you have, in order to be able to go down at a certain angle for the low water or come up, you're taking about a third of the existing finger pier away for a transition finger pier. So many of the residents that have 28, 30, 32-foot boats that bought a slip with a 40-foot finger pier can't tie their boat up in that slip anymore unless we went back to a fixed finger pier. I think Bonnie calls it a pile or I don't know, where it's a fixed finger pier. But now you're still back to where we were before, where we have a fixed finger pier that can either go underwater, or way before my time arriving here, the water was 3 feet lower. So if you now have a fixed finger pier, you're dropping from a fixed finger pier 3 feet down to your boat. So that was why the reasonable prudence said, let's go to a floating. But when you go to a floating, you have to have a transition from the main pier, and that's no longer usable space to tie up a boat. So then it came to, well, if we're going to do that, we have to rip out the fixed main dock and replace that with a floating main dock. And one comment on the 4 foot wide. Well, no, I'm not. I don't. It's not my time to say that. So I'll just stop there.
Okay, so just one follow-up question to either Mr. Brown or Mr. Cavedo. This $270,000 number, is that to not only remove the main shore pier, but also to replace it with a floating main pier?
That is correct. So we would be about 250, 270 plus the 150 that we're looking at right now for the finger pier replacement. So overall, it would be, close to a $400,000+ endeavor for the 28 of us slip holders to bear the cost, where it was originally borne by the developer and was wrapped into the cost of home ownership and sales of the slips.
Okay, thank you. I have 2 more questions. Relative to the design of a floating finger pier as compared to an open pile structure, and maybe this was contained in the documents that were previously submitted, but does the floating pier also involve pilings of some sort to anchor these floating piers? It slides up and down, so there's piers associated with both?
If you could envision at the edge, at the 4 corners of the floating pier, I think that they are scheduled to be 2-inch diameter steel pipes that will be driven in, and then there'll be like a coupling that goes around the steel pipe that the floating pier rises and lowers on those 4 corners of the steel 2-inch diameter pipes that get put into the ground. Some of the larger ones have, that have these big, massive, what we call bollards or pilings that are driven down into, a more commercial-like floating pier. But this is not a commercial; it's a private residence type floating pier.
Okay, so and Ms. Broadwater, maybe this will end up being a question for you when we get around to talking to you guys, but what the difference would be between the impact to the physical impact to the bottom land associated with a structure like these pilings as compared to an open pile. I assume that requires more pilings when you do the so-called fixed open pile pier. But also there's an issue that I'm picking up from the department's presentation relative to shading. And I would assume that there is more shade that comes off of a floating pier than a fixed open pile pier, just due to the depth or the type of construction. How thick is this floating pier that you're talking about? It's a solid structure, right? That's just
it is, yes, and I believe, and neither Bill or I were on the technical committee or but I think that this floating pier is about 18 inches thick, with about 9 inches below the water and 9 inches sort of above the water, something like that.
All right, thank you. And then the last question I have is you've referenced these for purposes of the context, other relatively new projects that have occurred, like at Four Winds, Spring Lake Yacht Club, Barrett's Marina, East Point RV Park. Relative to the physical location of those facilities, are those facilities subject to the same fetch kind of a situation that you have? Because one of the
I would say my unscientific answer is yes, but they're much more substantial, right? They're very substantial fixtures. If you were, as an example, the Spring Lake Yacht Club, their piers, their floating piers are, I've got photos of them, up close photos. The main one is 8 feet wide, but that's got to be 5 feet thick. And so it's a very substantial piece of apparatus, or things like that. So I would say that if you looked at them, you look at the winds that can go up the Grand River. Yes, I would say the same thing, but those are all fixed pilings up the Grand River. And if you were to look at the ones at Four Winds, you would see that those are all the reason that they can do a 4 foot wide finger pier is because the 4 foot wide finger pier is attached to a 6 foot wide floating pier, and then there's a 6 foot wide transition piece that comes from the shore, the fixed shore down to a 6 foot wide floating piece, and then the 6 foot wide dock and the 4 foot wide finger piers all go up and down in unison. So that's why they're able to do a 4 foot wide, because it connects to a 6 foot wide dock, and the entire thing goes up and down with transition to the shore. And again, if you look at it, it's a very substantial commercial operation. It's not what we're getting in, which are really private docks for private individuals that are able to be hooked to our fixed main pier. It's just, I mean, it's commercial and residential, I should say, is sort of the distinction.
Okay, thank you. All I would ask is that if the previous submittals or information that's been provided to us doesn't already contain, it would be nice to see an air photo, an image that shows a relative location of each of these, whether that's for the department to provide or for the applicant to provide. It would be informative to the panel, I think, to just see where these different structures are relative to each other. So thank you very much. I appreciate your answers to my questions and consideration.
All right, Jeff, are you ready for us to move on over to Evan?
Yes.
Okay,
Yes.
good. All right,
Great.
Evan, you're up.
Okay, great. Well, thanks for both of the presentations. I had been wondering about that whole surface area thing and whether we'd look at the bayou or elsewise. I think I do have a couple of 3 questions. First, I'm not sure if this is for Mr. Cavito or Mr. Brown, but so what kind of fish do you see out there off that dock? What do you guys fish for?
Bill?
Yeah, I can answer that question. So my kids love fishing off the dock. There's a lot of bluegill. They'll catch a bass every now and then, but it's mostly panfish that you'll find off of there. You'll see when the fishermen do come into that little cove. I call it a cove. It kind of looks like a cove to me. Yeah. When they come in, I mean, they travel right into the cove, and they're mostly fishing off of where you'll see our property line that kind of goes underwater in that picture, and they're fishing for whatever. I've seen them come in and fish at nighttime too. They'll fish down that cove, and they'll spear carp, I believe, and they'll do different things that I've never done myself. But even so, whether you're fishing at night or you're fishing in the daytime, when they come down that cove, a fisherman this year or a fisherman in 2022 or a fisherman from 2009, they're not going to know a difference when or if we replace those finger piers with 5 foot wide, because they're only concerned with that 40 foot length, and they wouldn't notice a difference coming down there fishing. And I just wanted to mention that because I was thinking about the public trust and and we didn't get any comments on that, but it was, I really do. I think the people that come over here and do fish in our cove, I don't think they're even going to notice difference with the project that we have, whether it's 4 foot or 5 foot. I honestly don't think anybody's going to notice any difference. And because we own those slips, there's always going to be boats in those slips. We talked about the shaded area. There's going to be boats in all those slips. So yeah, there's going to be a lot of shade from all those boats attached to either a 4 foot or a 5 foot wide finger pier. And I don't think, and I don't have the degrees and the credentials that Bonnie does, but I don't know that there's going to be that big of an impact with the shade because you're already going to have that marina filled up with boats and either a 4 or 5 foot finger pier. The surface area was something that I had trouble understanding, but my thought was, and if we had to rip down that main shoreline pier, which is above water, and we were forced to put a main shoreline floating pier, to me, that just seemed like a greater impact to the water. And I didn't want to do that personally. So I felt like we were doing our due diligence by replacing all the wood. We did, as a treasurer, we did sink about $5,000 into that main shoreline pier this year, even knowing we didn't have an approved permit, because we're trying to keep that out of the water, above water, and keep it as long as we possibly can. But to us, like, again, not having the knowledge of the, what is considered in or out of the water, but sinking a 8 foot wide, 550 foot floating pier into the water, just from my perspective, just seems like a huge impact. And I can't believe that the public would choose that over what we already have out there. So, thanks for letting me talk about that for just a minute. Thank you.
Yeah, and so I thought I saw something in the documentation that it was around 12 feet deep in that area, but I'm guessing that there's some kind of gradual transition to shore. So I'm looking to find out, roughly how deep is the water there? Is there a channel that's been dredged out for people to get back in there? Or Mr. Cavito, you may have an answer to that.
I can tell you exactly how deep it is right now because I had to dive down to the bottom and get my kid's electric scooter off the bottom after they took it down there on the pier that wasn't allowed to be on the pier, and the wind blew it over into the bottom, and I had to dive down to the bottom and pull their electric scooter up off the bottom, and it is exactly 7 feet 9 inches deep right there where I went down. And once the electric scooter is on the bottom for about 30 minutes, it's ruined. And now the kids are going to pay me back over the next year for their electric scooter that is now ruined and sitting in my garage in pieces.
That'd be a pretty big bag of rice, I guess.
Now, I will tell you, it's another thank you, because before my time here, at the east end of the slip, as the slip goes in from west to east, the head pier runs north-south, so the slips are all sort of east-west. 8 years ago, the water was so low that people's bow of their boats were basically sitting on the land inside the slip because it really does come up. But that's how low the water was. There was enough water to keep your hull floating and keep your motor out of the water. And the people that were furthest in couldn't even use their slips when the water was that low. And again, that gets us to why a floating finger pier is so necessary, because in an 8-year period of time, you've seen almost a 7-foot difference in water height from the highest water we had 12 months ago to the lowest water we had. I've seen pictures of it 8 years ago. Yeah. Right now, 7 foot 9 inches deep.
And would you say that's more or less consistent along the whole length of the head, or it varies?
It gets shallower. I can tell you, at finger pier number 1 or boat slip number 1, I think you've got about 3.5, 4 feet right there. Right?
Yeah. Okay.
So I'm out at the end. My slip is about 7 feet 9 deep right now.
Yeah. And so tell me, when you were down there, did you see a lot of aquatic vegetation? Are there things growing from the bottom, or what do you see down there?
On the east side of the main pier, where there are no finger piers, yes, there's quite a bit of vegetation there because it's only 3-4 feet deep at max on that side. And so, yes, you can see, I don't know what they're called, but there's a lot of plants that are just 2 or 3 inches below the surface. On the west side of the finger pier, or the west side of the main dock where the finger piers would be, there's nothing there. I've seen some green notices put up on trees all around down our walking path. There's green notices that look like somebody, I think they're a notice for the state or the county or somebody that comes in there and sprays, probably for invasive species in the water. I don't remember what that green notice stapled to the trees are about, but it's something from the state or the county saying that they're doing some treatment for some water plants, I guess. Don't know exactly what it is, but yeah. East side where no boats are, lots of vegetation. West side, it mirrors the rest of Bayou Meadows, or sorry, the rest of Petty's Bayou, which is we have hundreds of boats that come into our into Petty's Bayou every weekend and anchor and swim, because the big boats can't get in there because it's bridge restricted. And if the wind's not up, it's just a great place with great swimming. So hundreds of people come and anchor out in the main part of Petty's Bayou for swimming and fishing, etc.
Yeah. So maybe this is a question for Eagle. Maybe you don't have it right now. My next question was going to be whether there was any history of permitting for aquatic invasive treatment type of thing. Sounds like the association has not been doing that, but maybe somebody has, maybe somebody hasn't. Do we know that, or?
I would need to look into that. I don't know the answer off the top of my head.
Okay. I didn't see anything. I saw the general information with the citations about how, shade can certainly be impactful to habitat. What I'm considering is, again, that surface area ratio, what are we really talking about for the impacts? But I was also considering, as I think some of our panelists know and understand, that water depth certainly has an impact on plants. And of course, some fish are like to wander around and have a little bit of cover. Not everybody likes that, I guess, but some of them find the munchies in there. So I'm just trying to get a handle on, how disturbed is our ecosystem, and how impactful would what we're talking about be, essentially whether we're talking about a foot or a foot and a half either direction, depending on where we put our yardstick and what point in history are we yardsticking. So another question I do have, again, Mr. Cavito, when I looked at the aerial imagery out there, I don't know the specific boundaries of Bayou Meadows, but it looked like there were a number of similar homes. It looked like some people that are on the point, kind of, I'll say, towards the south side of the property or southeast side of the property might have individual piers. Is that correct? Some people have just said, I'll just pay for my own thing. I don't need a shared common slip. I don't know if there were 8, 10, 12 of those.
That is true. So although we are 23 houses for Bayou Meadows 2, there's a Bayou Meadows 1 that was the original, and that's further to our south, and about, I don't know, wrapping around the south and then back up another cove going to the north is part of Bayou Meadows 1. And I would say they all have shore property. My house, I'm a 5-minute walk from the marina. They all have shore property, and they have, and I would assume, permitted for and receive permits for their own private docks coming off their property. And I would say 8 or 9 of the people in Bayou Meadows 1 have their own dock. There are residents of Bayou Meadows 1 who own slips in Bayou Meadows 2. So it's a convoluted thing that Bill and I are trying to, manage after 20 some years of other people managing it. So yes.
Yeah.
Long answer to a short question. Yes.
Yeah, that's pretty common. Riparian owners have their own docks, and folks who have access rights but are non-riparian are often looking to partner up and use that common space. And Mr. Anthony said he's been on a planning commission for a while. It would be no unusual thing to see a developer get approved for a big plan, which in this case was, 2 shared docks, and then a development gets phased, budgets get cut, and we end up where we are today, basically. So I guess that's maybe a good thing where people kind of got to decide in that other area, because it does look less impactful than the other half of the dock area. And certainly I'm familiar with the notion of that, private marina classification. It's just, it's kind of just like calling something an apartment building if it has more than 4 units. There's plenty of apartments that don't look like apartments or what have you, but they're different than, the single family type of stuff. So that helps me with that. Bonnie, I did want to ask or just confirm, though, again, I saw the general information from Mr. Calabro, if I'm saying that right, on just in general shading and habitat, but there hasn't been anything specific to this area we're looking at it, or is there anything more that our panel should know about the current nature of the habitat in that vicinity?
So I would just add that, the guidance that we've received from DNR Fisheries with regard to fisheries work window restrictions includes the time between March 1st and June 30th for work window closures, and that's to address spawning and habitat use by northern pike, largemouth bass, and bluegill. And so specifically those 3 species we know are using these types of areas to spawn, and that's why we provide those work window closures. Additionally, I would also like to point out that, for these types of structures, you had inquired about the distinction between the floating and the open pile. And while we're not necessarily looking at the span between the water and the structure itself, the shading is of interest. And while that 4-foot wide finger pier width is consistent with what we're seeing at other commercial marinas, the 8-foot wide head pier width is also consistent. So those dimensions are both consistent with what we're seeing throughout the area and other commercial marinas in the area, as well as district-wide.
Yeah, good. And I had the same questions that Mr. King did, as far as, feeling like a driven, wooden pile or other material, a more substantial one that you'd have with a solid dock would seem quite a bit more impactful than having the, little 2-inch augered piers at less locations too. I mean, those are just to provide that stability and allow for the dock to slide up and down on those couplings. That I've certainly seen those type of things before, and I'm sure many of us have seen it. Maybe we haven't noticed it. Unfortunately, I'm an engineer, so I'm always eyeballing all that crazy stuff. So I think that's probably the extent of the questions that I have right this second. Let me just double check my notes. Actually, one other question. I didn't hear about the status of the Army Corps. So I saw in the materials provided to us that they had sent what looked like kind of a courtesy heads up to at least Eagle, if not the local health department, of, hey, we're processing this permit. We think we're probably ready to issue, but we want to check in with you all first. We see it as a minor type of deal. So that was the Army Corps' thinking. That was back in April, I believe. And I admit I didn't read every single document. I was kind of looking for what jumped out in the file, but I'm presuming Eagle asked Army Corps to hold off for a bit, or what was that conversation, I guess, Bonnie? Where are we at with the Army Corps?
Sure. So under our review for the Coastal Zone Management Certification, or CZM, we would need to make a permit decision. And then based on that permit decision, we would then, copy Army Corps on that, and they would then move forward with their review. So typically Army Corps does issue after Eagle. If we're unable to provide that CZM certification through our review because a permit was determined that it was not able to be issued, then at that point, Army Corps would most likely not be able to issue a permit.
Yeah, I got you. Mr. Cavito, did you have something to add there?
If I may here, and it goes back to the sort of the standard that the Eagle has seen, the 8-foot wide by the 4-foot wide floating. Like we've said, that would be wonderful. What we have seen is that typically when that is the case, that the 8-foot wide head piers and 4-foot wides are all floating in unison. And that became one of our challenges, is our 8-foot wide is not, it's a fixed finger pier. So having the stability to go from that down to a floating pier, that was what became, although I think that we ultimately, if this is denied and we have no other choice, then we're going to have to go figure out how to do a 4-foot wide. It's suboptimal. It is less, right? Like I mentioned in my presentation, everybody could make it smaller, right? Every single application who's been approved in the past could have been smaller. But I think that was our challenge, without converting our fixed 8-foot pier into a floating pier so it could float in unison with the finger pier. Then it became this challenge of having now a finger pier that's floating next to a fixed pier, and the wider makes it more stable, especially when you have a very heavy hinged ramp that is resting on top of the floating finger pier. When it's all together and all in unison, there is no heavy ramp that's putting pressure on it. Everything's just going up together and coming down together. I thought that was, again, not an engineer, but that was a distinguishing fact.
Yeah, that makes sense. Okay. Tony, that's good for my questions. If you want to take over here with any questions you've got.
Good. Thank you, Evan. You know what? I echo the questions of both my colleagues, of Evan and Jeff. Those were good questions.
You went away again, Tony. You're in your own silent movie there as the star.
Oops. All right. So both John, William, and Bonnie, my questions sometimes can sound abrupt, but I'm really just trying to now collect data so we can fill the gap and tie everything together with what my colleagues were looking at. First, for John and William. Now, I'll tell you, here's the part that I'm struggling with, and that is that the reasons for why a 4-foot wide finger pier won't work to a bit have shifted, and even today have shifted. For instance, when I look at one of your submittals from Wave Armor, they themselves, in one of the letters they presented, the first thing they say is the 40-inch by 120-inch wave docks are designed to be used as finger piers, coming off main docks, serving as a viable access to watercrafts. So they even say that that's the reason that they're designed for. But then they go into the next paragraph, and then they say that the buoyancy is at risk for people walking on it, which then is extremely puzzling on why do they manufacture it and sell it if people are at risk on it. So from there, I extrapolated that perhaps it's the ramp that you guys were talking about. But at some point, somewhere within there, whether you have the main dock that's floating or whether you have the finger pier that's floating, there's going to have to be a ramp so that people will have to move through. So today, I heard that the concern with the ramp is that it shortens the usable linear footage of the finger pier. But when I took the construction drawings that were submitted in later information, it looks as though your 40-foot is now down to a 30-foot of usable space. But one, I didn't hear of any boats that are greater than 30 feet. And when you get to a boat that's much larger than 30 feet, looking at how shallow the water is there, I wonder if there's some inconsistency there. So help me clear that up.
If I may, sir, the first part of your question is understandable and reasonable, and I would agree with you that it's not a 48-inch floating pier. It's now only a 40-inch because Wave Armor has a 40-inch, not 4-foot. So it's a 40-inch wide floating finger pier. And although they do not make a hinge transition piece, we could go to a third party and get a hinge transition piece. What Wave Armor said, though, is on a 40-inch wide floating finger pier, the weight of the hinge transition piece resting on it with people walking on it, that would not be enough buoyancy to withstand the weight of the ramp resting on it with people then walking on it. It became problematic going that because you're going from a 40-inch wide to a 60-inch wide floating finger pier, much more buoyant. I don't know what the percentage of increased buoyancy is, but that is able to withstand the weight of the hinged ramp. So it became, although it is, like I said, you can get the 40-inch, those by Wave Armor said are typically attached to a floating main dock. When everything is in unison and you don't have to use a hinged transition piece, you don't get that extra weight of the hinged ramp resting on top of the 40-inch narrow floating ramp. So again, I don't have the details in front of me about what the percentage of buoyancy is increased from their 40-inch to their 60-inch wide finger pier, but that was the rationale at the time, was that 40 inches was just too narrow because it is attached to a fixed dock. It would be the equivalent of 4 winds going from their main their shore down to a 40 inch. Right? That's not what your question was, but that was it. It was too narrow to sustain the weight of somebody walking on it, coupled with a hinged ramp. If everything was floating in unison, it would have been okay. 40 inches would have been tolerable if we had ripped out the main head pier and replaced the entire main head pier with a floating 560-foot floating head pier.
So the hinge, the ramp though, is connected to the fixed pier.
That's right, on a hinge, and it rests with wheels on the other end. So as the dock goes up and down, it can roll up and down as the finger pier goes up and down with the water.
I didn't put calculations to it, but it just intuitively without that just seems like the bulk of the weight's going to be transferred onto the connection to the fixed pier. But I guess that's something that we can look at. So that so that's one of the things that after this meeting and over time with my peers that I would need to resolve is truly the impact of the hinged component on the use of the dock, of the floating dock. And it's, again, it just seems counterintuitive to me that they're marketing, selling these docks, and even in the floating and hinge sense that their concern of being able to sustain a person's weight. I know they did put some calculations on buoyancy per square foot. I didn't do any math on that we could take a look at that. So that's a safety issue on the dock. So I don't think the safety issue, even though it's a viable concern, is necessarily an element in the permit. But it is a good point for you to bring up. I do want to say, though, that I did like your calculations on the relative area. I'm glad that you were looking at that and grasping that. I had done that myself as well in preparation for the meeting. However, when I did that calculation, I used a much smaller area. The one thing about being further up in the lake system and being in the shallow water where you are is you are in an ecologically more sensitive area. I had used the Bay area, I think that for lack of a better term right there, as the area when we did the calculation, but I think it still showed a very small increase in the surface area that of the increase of the docks that you were requesting. And I'm going to shift this now over to Bonnie. And Bonnie, it seemed to me like this was it wasn't a concern with interference with navigation. So as far as interference with the navigable waters, I didn't see that. And I didn't think that you had brought that up as a concern, that your area of concern had to do with ecological impact. Is that correct in how I'm reading this?
You are correct that navigation was not one of the issues identified as a primary concern, and that ecological impacts were. The other primary area that we identified the application as being deficient was in the feasible and prudent alternatives analysis.
So the reason I did the surface area initially was I started to want to get a handle on the dissolved oxygen content. So John and William, for your benefit, one of the big concerns of any of our inland lakes is dissolved oxygen content. When that becomes depleted, not only do you lose species and habitat, but the lake itself will begin to fill, and you'll end up with the problem of the lake being too shallow. So there are a lot of factors, though, that really seem to affect dissolved oxygen, whether we're looking at thermocline, whether we're looking at the turnover of the thermocline seasonally, diffusion of oxygen across the area. So the surface area argument, to me, again, without putting any calculation to it, seemed minimal and maybe fit within that category. But the aspect that the surface area doesn't account for is the plant life that's in the water, and that is below below the dock. And you had provided, when you were making that argument, that the shading would run the risk of killing off vegetation. The decay of the vegetation would consume dissolved oxygen, and that the growth of the vegetation would be minimized, so that the production and off-gassing of oxygen from the plant would be diminished. So the question that I have is that the engineer in me now wanted to take that qualitative concept and try to quantify it. And so you had cited an article by Garrison in 2005 of work that he did in Wisconsin, because I know we talked about the thickness of the dock since they're floating directly on the water, so you may get less sunlight that penetrates in that area. But if any of you guys, John, I know you said you dive, but if any one of you guys scuba dive, you know, you actually get some diffusion of sunlight once you get into the water. So I'm curious if you could actually provide that paper at some point, because it seemed the regulation gives you the ability to look and say, hey, this causes degradation and therefore wouldn't approve it. But let's see if we can, but it doesn't give any necessary guideline on a dock that's 5 feet versus 4 feet versus 3 feet to the degree of degradation, that ecological degradation that it can cause. So it'd be nice if we could see what they observed and what's in the literature, so that we can then quantify that aspect that you are concerned about. So that would be a paper that I would request as well.
Certainly, we can get a copy of that paper for you.
Okay. So in summary, I feel, John and William, your argument is, one, this is time sensitive. Two, the methods or the that the state is giving you are reducing the boats that can use the dock, and that you're concerned about the safety of people walking on that. And yet, keep in mind that I'm looking at this as it is less safe than the 3 foot that you would have had before. You're in a situation to where you had a previous permit, and just like in cities when we go through planning commission, new information is gained over the decades and over the years, so that regulation or ordinances are modified. And though if these were approved before those changes, you're grandfathered in, at the point to which you go and replace those, which it probably is wise not to demolish the main dock, those elements now are looked at with the updated information that's there. And I think that's partly what you're caught in, an ecologically sensitive area with some new data and updates on ecological degradation that shading is causing. So let's see if we can't quantify that and truly see if it's an effect here or not. The safety issue, I think, is yours. I think that's something that's independent of our permit process that you'll have to look at. Evan, Jeff, do you guys have any other comments to or questions to bring up?
Yes, I do. And I apologize. Earlier, I was trying to focus my earlier questions to the applicant, not necessarily the department. So I'd like to direct a couple questions to Ms. Broadwater. And it kind of goes to the issues, Tony, that you were just talking about as to the degree of ecological degradation that the department is suggesting. Bonnie, did you solicit input and receive any input from the fisheries division or anyone in Eagle relative to the specific impacts of this project and get any comments? I assume you didn't get any because you would have provided them to us, but what's the status of fisheries division review or other agency people that might be giving comments specific to this project?
Sure. So we are provided with general in-water work closure date guidelines from DNR Fisheries that are geographic to water bodies. So those are applicable in this specific situation. Above and beyond that, we did not receive any specific project comments from DNR Fisheries related to the activities proposed in this application. We did also receive additional information which was provided to you with the narrative from Eric Calabro with Eagle. And that was the document that cited specifically some of the peer-reviewed literature that you asked for copies of, as well as kind of some of a more specific discussion related to the ecological impacts associated with the placement of structures over bottomland.
Okay, just a comment on that. I'm getting an echo. Are you guys? I'm turning off. Does that help at all? Is it easier to hear me?
Yes, that's much better, Jeff.
All right, I'm just turning off my camera then. In my experience, when the department goes to a contested case hearing, it sounds like this one's on the road to that, and we've been sort of preempted by this process. But the department would typically solicit and receive input from fisheries biologists or wildlife biologists or those that are, assigned by the department in that specific area of expertise to specifically address these kinds of issues. Because what we're talking about here is not a general concept of what is being proposed, unless that's a programmatic issue that the department is concerned about relative to other projects involving larger structures in the water. But what is the actual impact of this project on this specific resource? Because as resource managers and department administering the program, it seems like each project needs to be reviewed individually on its own merits, and that we're a little premature at this point in the process, although the way the commission is set up and the opportunity for the applicant to apply for such a review is, the timing isn't good. The kind of questions that Tony's asking about, to me, would seem to be played out a little more thoroughly in a contested case, or perhaps if the discussion could go on further between the applicant and the department. Some of these things might be a little clearer to us than they currently are. So that concerns me a little bit, that where we are in the process is a little short of where we probably should be in order to make an informed decision. Although, as Amy pointed out early on, we're not necessarily making a decision here, we're making a recommendation. So, I think we need to talk about that. But one thing, another kind of related issue that I guess this is a question for Ms. Broadwater, is even if the impact to the resource here is determined by someone, some independent or objective or whatever some other party, and the department were to agree with that, is the department of the opinion that the alternatives analysis still needs to be reviewed, or more documentation needs to be provided by the applicant relative to alternatives to feel comfortable in issuing a permit, even if the impacts are determined to be minimal or negligible? What is your opinion about the alternatives analysis side of this issue?
Well, I did attempt to address this a little bit in the narrative, but I think that, the bottom line here is that the applicant has asserted that there are feasible and prudent alternatives that are available to them. And those alternatives have not been really suitably addressed. The statute's pretty clear that the department cannot issue a permit if there are feasible and prudent alternatives available. And at this time, that does appear to be the case.
Yeah, I think for the benefit of the panel, in my experience, and you please correct me if you feel differently about this project, but the level to which the department would traditionally hold the detail associated with an alternatives analysis has some proportion to the impact that is potentially to be permitted or denied for that matter. But there's a question here again that I'm not sure is quite right, because I don't know if the department's taking the position that there are alternatives. I think the applicant would probably take issue. They think there are alternatives. They're interpreting what they're saying, if they haven't said it directly, to say they're not feasible or prudent, one or the other, in their opinion. That's why we're here. There are alternatives. They're admitting there's a bunch. They reviewed them. I guess maybe this is, sorry, I'm rambling here a little bit, but they had mentioned in a previous meeting with the department that they talked about other alternatives with you, with the department staff, and that the department, and I don't want to misquote here, but that the department thought that those alternatives weren't, how do I say, that they were feasible or that they were prudent, and that you were more or less rejecting the idea that they weren't. But was that ever provided in writing so that the department could formally respond to that? Or was that just in the course of conversation, they got the impression, look, we're beating our heads against the wall here a little bit. You're not going to approve what we're going to give you anyway, so they just didn't do it? I don't know that you can answer that for them. But am I characterizing from Eagle's perspective the tone of that kind of conversation?
We did not receive a detailed alternatives analysis that included all of the manufacturers that they've addressed in their subsequent discussion until after they had approached or petitioned for an environmental permit review. None of that material was provided prior to that time. It was only discussed verbally.
Okay. So you haven't officially reviewed any alternatives analysis, additional alternatives analysis information to completely rule out the fact that what they're talking about isn't feasible or prudent necessarily.
During our subsequent meetings with the applicant, Eagle had two after they petitioned for environmental permit review commission. We did discuss the additional material that they had provided. And at this time, it is our understanding that this is not a suitable alternatives analysis. This is not sufficient. There are feasible and prudent alternatives available to the applicant.
Okay, thank you. I think I'm done with my questions along those lines. Thanks. Sorry for the echo.
All right, good. I appreciate that, the discussion from everyone and all the information that's been provided. If there are no other questions or point of discussion from my panel colleagues, we can move on to the next portion of the agenda, which is the public comment for the Open Meetings Act. And with that, I'll turn that over to Dale.
Yes, I'm looking at the attendance and I don't see anybody that has joined us that is outside of this discussion, but just in case, is there anybody that wanted to make a public comment? Okay, yeah, I'm not seeing anybody that has joined the meeting outside of Eagle or Mr. Brown or Cavito. So I'm going to go ahead and pass it back over to you to discuss next steps.
All right, good. So the next step actually on our agenda is adjournment, but before we go there, I think there has been a request for additional information from Dale. From what I understand is now the panel will have 45 days to review information and then to provide their opinion if for in next steps. And in moving or preparing for those next steps, I think there has been a request for additional information. One, I asked for a specific paper that was referenced by the state.
Just a quick clarification. By August 26th, the panel has to submit their recommendation to the Eagle director.
Okay.
So whatever steps takes place in between that today and that day is when we have to have the recommendation. And yeah, I just wanted to clarify that.
Yep. Paper was referenced as Garrison 2005, which dealt with shading, the effect of shading on aquatic habitats in inland lakes of Wisconsin. I believe there was a request for additional information. Jeff, did you request additional engineering information on the docks? I had something jotted in my notes.
Not necessarily if it was already provided as a detail for the floating structures. And I think they answered my questions for the most part in terms of the depth and, you know, the actual 18 inches or so, 9 inches of which are in the water, that sort of thing. I think that answered that question. The only other document that I asked for that I don't remember seeing in the packet was some sort of an aerial that would show us the various locations of these other referenced facilities. I don't know who's best to provide that to us, but unless it's already there, if it is, I'm sorry I missed it.
And Bonnie, I presume that the state does not have any current information on dissolved oxygen levels in that area of the lake over the course of a year?
I would need to review our records to answer that, but I'm happy to look into it.
Yep, if you do have that, that's going to be very helpful. I have a feeling that with the presence of carp, that there are areas where the oxygen level is already low. That would be helpful for us as well. Dale, are we allowed as a panel committee to also meet and discuss, since we're issuing a panel recommendation, so that we could meet and talk as a panel without violating the Meetings Act? Or maybe that question's for Robert. So.
Yes, my understanding of the statute is that the panel is to conduct its business consistent with the Open Meetings Act. So that if you were going to deliberate or discuss what your recommendation is going to be, you would need to do that in the context of a meeting open to the public.
How do we then issue a consistent opinion of the panel if we're not able to have that discussion? Or do we reconvene a meeting of just the panel?
Well, again, the panel's function or work is subject to the Open Meetings Act. if you have things you want to discuss, and certainly understand why the members of the panel would want to discuss among yourselves your respective thoughts on what you think the recommendation to the director should be, that's certainly understandable. But as a legal matter, as in a practical matter, you'd have to convene another meeting.
Okay.
Be an opportunity. And again, even though it may seem, I don't want to characterize it as odd, but other panels, including panels that are reviewing decisions by administrative law judges, are required to and do have their discussion or deliberations conducted in an open fashion. So the bottom line is, if, as it seems likely, the panel wants to convene to talk about this again, you would need to schedule a meeting. Or
Okay.
staff obviously
Because
could assist you with that.
this is my first time through this process, and I would see in working with other professionals as a panel, once we have some additional information and we're able to take these discussions and go back and look at them ourselves, that we would want to have that discussion again. Is there a length of time that's required for public notification of another meeting for an Opens Meeting Act, a 14-day, a 30-day, or is that something that can be established ourselves?
I think that you would have to, and I'm embarrassed to admit this, I'm not certain, I think you would have to have at least 7 days prior notice.
Okay. Oh, that's a good time. Evan and Jeff, would you want to reconvene, say, 2 weeks from now, or 3 weeks from now, with additional information?
Yes, and probably sooner rather than later, right? I mean,
Yeah.
I don't think this is the most complicated situation in the world. There's a lot of nuances and a lot of information, but I feel like we're kind of at the 5-yard line with what we had, and we haven't asked for a lot more. So 2 weeks would be great.
So do I need to make a motion for a meeting on July 26th of the panel?
Yes, if you decide an action to decide your next steps, that you would need a motion, support, and a vote on that motion.
Okay. So would one of my colleagues like to make a motion for a meeting of the panel on July 26th?
I know I'm available that morning, and I'm also available on the 27th. So maybe a quick straw poll with what you and Jeff have for availability. I know Dale can do the doodle poll, but we're all here, so.
Yeah, I can. I'm available for both. How about you, Jeff?
One moment, please. I think I'm available. Let me check.
I just want to clarify while you're checking, are we going to be able to provide all the requested documentation by the 26th? Is that an issue for anybody that was requested to have info?
I'm available, and no, I'm hoping, assuming that somebody can provide that graphic in relatively short order.
Right, and even though I'm asking Bonnie to provide that paper by Griffin's, I'm gonna, as soon as we're off here, I'm gonna go look it up and order it myself, so.
Okay, can you clarify when you're available for the next meeting? When did you want to schedule it? 7:26, was it morning or afternoon?
The 26th, why don't we say 9 o'clock again, gentlemen?
Works.
Oh, and just to keep in mind that any open meetings we have going forward has to be in person. Today is the last day for Open Meetings Act requirements that we're allowed to do this virtually.
I don't have any problem with meeting in person. Let's see, we've got one in Washtenaw County. I'm in Oakland County. You're in the middle. We could meet in Lansing.
Yeah, I would be at Constitution Hall.
Okay.
Yeah, I've got a noontime situation on the 26th. I'd feel safer if we could do the 27th.
Okay, I'm good
Me
with
too.
that. I just couldn't do it. So the 27th, if we were to put that at 10 a.m., I just have a very early call.
Not a problem.
No, sounds good to me.
All right.
Tony, a question, or maybe this is a question for Mr. Reichel. The fact that Bonnie and I were discussing a little bit earlier about this additional alternatives information that has been discussed but not necessarily provided in writing. Is it inappropriate for us to encourage the applicant to provide more detail relative to that issue so that the department can be better prepared to address, even if it is reject, the presumption that I assume the applicant will make that those alternatives are not feasible or prudent? Can we be doing that during this time, or are we kind of left with, the record as it sits today?
The short answer is, if the panel desires either the department or the applicant to provide additional information, you're free to do so. And just to contrast this situation, where you're reviewing the positions of the parties before a permit decision is made, with a situation where you're reviewing a decision that's already been made in a contested case. In the latter, you are, or the panel in that situation is limited to the record that then exists. That constraint doesn't apply here. So if the panel wishes to request, as you already have on a couple of items, additional information related to the issue raised by the petition, you're free to ask either party to do so.
Okay, so for example, it would be my recommendation that the applicant provide a more thorough alternatives analysis as to what they determine to be the feasibility or prudency of any particular alternative, and then provide that to the department as well as the panel. And then ideally, if I can take this a step further, to get the department's position on that prior to the next meeting. That would be, to me, seem to be an important point of discussion for the panel anyway, to understand if there's been some agreement, because if there's been some agreement, maybe we don't have to, burden the panel with that part of the recommendation.
So Jeff, if I have this correctly, it would be a motion stating that the applicant may provide a more detailed feasibility and alternatives analysis prior to July 27th. I want to put the word may in there because they may just want to stand on the information they've already provided.
Right. If you don't mind, can we add encourage? The panel would encourage them to do that.
Okay, stating that the panel encourages.
And I don't recall seeing it, if I understood Bonnie correctly, they did provide something supplemental in writing, and I think Eagle found it didn't pass muster. I don't believe I reviewed that, so I'm not familiar with what they've already written down, because I kind of agree with Tony. I don't want to be overly burdensome. I looked online and saw that there were a variety of options. I didn't see anything online that was different than what I heard the applicants verbally describe today. But I also understand that it's helpful for Eagle to have something on record that is a written summary of the decision process. I know when I've gone through permitting before, I've been in the same position as those applicants, feeling like there really aren't many options, and I'm sorry I didn't explain all the things that I looked at and just didn't make sense for our organization, et cetera. But sometimes it's like adding 7 more things that don't make sense. Do we need to do that if we've already identified, look, here's a couple of 3 things that clearly are no better off. We looked at some other things and, you know, how many trees do we need to kill here?
Right. And to tell you, you know, William and John, what Jeff is trying to do is help you guys out because you weren't working with an attorney or with a consultant, not recognizing the detail of the process. When we are looking at that alternatives analysis, the feasibility analysis, we could have jumped right to any ecological impact that each of these alternatives had. What's the baseline ecological condition of the site, and what's the effect that these had? And we didn't have that, and neither did Bonnie. So therefore, Bonnie would naturally just default to this can have an ecological damage. So whether we end up doing that ourselves as we get this available literature, or you provide something that can also help balance what we're looking at. So I'm just letting you know the process that we're trying to take you through. Jeff's trying to help you guys out as we go through this. So with that, I believe that Jeff King has made a motion stating that the panel is encourages the applicant to provide a more detailed feasibility analysis of the alternatives. Is there a second, or is there a second for that motion?
Support.
All those in favor of this motion?
Aye.
Aye. All those opposed? So the motion passes. Second motion that we have is that the panel will reconvene on July 27th at 10 a.m. in Lansing at Constitutional Hall. Do I have a second for that motion?
Second.
And all those in favor?
Aye.
Aye.
Motion passes. Yeah, is there any final comment before we adjourn the meeting? Yeah, John?
For the record, you had asked for, yes, sir, thank you, Mr. Chair, but for the record, you had asked for a copy as you were going through the request and the due outs. You had asked for a copy of my latest presentation, my updated presentation. And so I will send that latest updated presentation. And for Mr. Pratt, I will put that overview, the Google Earth picture of Spring Lake, Petty's Bayou, and where the other relative locations were to our. I will include that. That will be an additive chart to my presentation. I will send my presentation as a PDF. It will not be a build PowerPoint, but it'll be exactly what you saw with the inclusion of one additional chart, which will be the area of all and pinpointed the 4 or 5 different places I gave for context.
All right, good. And I presume all information will go to Dale, and then Dale, you will distribute it. Is that a fair assumption?
Yeah, fair.
Okay, good. All right. Without any other comment, do we have a motion to adjourn the meeting?
So move.
And we have a motion by Jeff and second by Evan. All those in favor of adjournment?
Aye.
All those opposed? Meeting's adjourned.
Thank you, everyone.
Thank
Okay,
you
thank you.
very much.
Applicants and staff.
Thank you.
Yeah.
Bye.
Very good. All right, bye, everyone.